It's usually several months between the time the court holds oral argument in a case and the time that the court hands down its decision in the case. And the reason for that, of course, is because it takes time to write the opinions that are going to accompany the decision. When the justices start writing, they circulate the opinions as they complete them. So when the author of the majority or plurality opinion completes their draft, they're circulated to the other 9 justices for review. And the same is true of concurrences and dissents. And the other justices have an opportunity to comment and weigh in and suggest changes. So there's a significant amount of negotiation that goes on during this period. And what it also means is that the opinions respond to each other when they're actually released. So when you read the majority opinion, it will make reference to oftentimes the dissent and the arguments that the dissent has made, and the dissent will do the same for the majority opinion. And again, this is a way that we hopefully get better reasoned legal opinions. And it is a process of negotiation because individuals can change their vote. We indicated that during the conference the vote is tentative, and they can change their vote as they think about it and perhaps get persuaded by somebody's opinion. And in fact, oftentimes justices will negotiate and make changes to their own opinions as a way to get justices to change their vote and to join their opinions. And if, let's say, for example, the original vote was 5-4, somebody changes their mind, then it becomes a 5-4 decision in the other direction. So it's possible for a majority decision to become a minority decision, and so on, and vice versa. And in fact, we talked about that happening when John Paul Stevens changed his vote in Bowers v. Hardwick. So this is not necessarily infrequent. Now, a really good example of this process of negotiation occurred during the case of Brown v. Board of Education. Brown v. Board of Education, of course, was one of the most important decisions the Supreme Court ever reached. Made sweeping changes in the law and called for massive social change. And yet, this was a 9-0 decision. We think about the Supreme Court as having lots of 5-4 decisions, but one of the most important controversial decisions in its entire history was a 9-0 decision, and in fact it was a very short decision, only running a few pages in the official Supreme Court reports. So how did that come about? Well, it was actually a historical accident. Brown v. Board of Education was decided in 1954, but it was originally argued in front of the Supreme Court in 1952, 2 years earlier. And then when the court went into conference, they had their vote, and a majority of the court voted to uphold segregated schools. This was the law at the time. The precedent was that separate but equal was constitutional, and a majority of the court said that we shouldn't overturn precedent and that segregated schools are constitutional. But there were various issues, and so the court decided that it didn't want to rule at that time, and so it voted to hold the case over for a year and to re-argue the case in 1953. Now that was a very fortuitous event because something important happened in the intervening period, and that is Chief Justice Vinson died. Chief Justice Vinson was one of the members of the majority who voted to uphold segregated schools. Vinson was also not a particularly well-liked individual, and I just want to show you this story. When he was on the Supreme Court, Chief Justice Justice Felix Frankfurter didn't get along very well with Chief Justice Vinson, and what he said when Chief Justice Vinson died is one of my absolute favorite stories of all time on the Supreme Court, and it was actually dramatized in a mini-series about the Brown v. Board of Education decision, which is excellent, called Separate but Equal. So let's just take a quick look at Felix Frankfurter's reaction when he was informed of the death of Chief Justice Vinson.
Afternoon, sir. Mark. Was it a nice service?
Yes.
Was the president there?
Oh, yes.
Mark?
This is the first solid piece of evidence I've ever had that there is a God in heaven.
Vinson's death had significant consequences because the court then held oral argument again in 1953, and this time when they went in to vote, the vote was 6-3 in favor of striking down segregation, so the outcome of the case was entirely different. However, the vote was only 6-3. The new Chief Justice was a man named Earl Warren, and Warren didn't want a 6-3 vote. He wanted a unanimous decision. He was concerned. He knew that this was going to be a controversial decision and that whites in the South would oppose it dramatically. And as a result, he wanted the court to present a united front. This all goes back to the question of legitimacy. He wanted the court to be united. He didn't want there to be any concurrences. He didn't want there to be any dissents. He didn't want anybody in the country who opposed the decision to have anything they could point to as a crack in the facade that the court was putting forward. And so Earl Warren made it his duty, his task, to get together a unanimous vote and to bring those three other justices to his side. And so the first thing that he did was he assigned the opinion to himself. He then engaged in an intense process of negotiations with the other three justices, and he made various concessions to them. They asked for various changes to the opinion, changes that he made, and ultimately they all changed their mind, and the decision was indeed handed down unanimously with no concurrences and no dissents. However, this is sort of an object lesson because although he got the unanimous victory, it was sort of a Pyrrhic victory because the concessions that he had to make probably undermined the unanimous vote that he obtained. For example, the most famous thing was that he agreed to have a second case argued the second year to figure out how to implement Brown v. Board of Education, so he delayed the implementation of Brown v. Board. But more importantly, in the decision that was actually written, they said that the schools had to desegregate with all deliberate speed, and that became a very infamous phrase because what Warren was hoping was that the Southerners would emphasize speed, but of course they emphasized deliberate, and it gave them an opportunity to drag their feet in any case. But nevertheless, his achievement in getting a unanimous vote is significant. Again, we're going to watch a little clip from Separate but Equal that sort of illustrates a little bit of the process that Warren went through to gain this unanimous decision.
Douglas, Black, Minton, Burton, Warren, Frankfurter, Jackson, Clark, and Reed.
May I guess why you're here? I will vote to desegregate. If the opinion gives the Southern states time. We are not dealing just with law, we are dealing with a social revolution. It needs time.
You read that, Tom. It may need some refinement. I'd like to accommodate your view. Stanley, I've written this opinion in a way which I hope will unite the court.
There is a word that's been on my mind of late. Cryptocracy. K-R-Y-T-O-C-R-A-C-Y. I checked it last night in the Oxford Dictionary. It says government by judges. I do not want to see this court travel outside its authority. It isn't a question of what I would like to say, but what the Constitution will permit me to say. And Earl, understand this. I do not believe that Negroes are an inferior race.
A little bout with one's mortality as a way of focusing the mind. Since the end of the Civil War, the United States has been hesitating between two worlds. One dead, the other powerless to be born. What you have written is quite remarkable. In very plain and understandable words, it tells the nation what must be done and why. I'm with you, Earl.
You're all by yourself now, Stanley.
The fact remains, this court has been given no evidence that the nation knew a century ago that it was outlawing separate
Stanley, we
schools.
have 8 votes to desegregate. Each of us is concerned about history. Each of us is reluctant to overrule precedents. But we are convinced that the law in this day and age cannot set Negro school children apart. Not in the United States of America.
This country has been making consistent progress in race relations. This decision could impede that progress, halt the march. A piece of paper cannot eradicate the fears and prides and prejudices of the people. Earl, if this court tries to force the southern states to change overnight, there will be resistance, litigation, disobedience, and years of conflict. Believe me.
Stanley, I'm a politician. I've worked for the people for over 30 years now. I've seen them in police stations, hospitals, unemployment lines. I'm convinced that the people will accept a ruling that fortifies their inner conscience. Let the backbone come from the court, and it'll strengthen the moral backbone of the people who live in conflict. Stanley, a fully united court will send a signal to this nation. I pray that you'll see your way clear to join the majority.
The justices, of course, are professionals, but they are also human beings, and although they behave mostly in a professional manner, their own personalities and their interpersonal dynamics can indeed affect the way that opinions are written. Interpersonal relations affect all small groups, and the Supreme Court, being a small group, is no exception. Now, I want to make clear that the justices, for the most part, get along. We're going to talk in our next lecture about some of the reasons why they fight, But for the most part, they are friendly. In fact, as you read about the oath, you'll discover that Antonin Scalia and Ruth Bader Ginsburg were good friends and would have holiday parties together, despite the fact that they disagreed on most of the major issues of the day. But sometimes their hostility, whether personal or professional, will come out in their opinions. And although many justices are guilty of this, one of the justices who was most notorious for this was Antonin Scalia. Wonderful writer, and particularly when he was concurring or dissenting, he would use his gifts to insult his fellow justices. Let's take a look at a couple of his opinions. One was an abortion case called Webster v. Reproductive Health Services. In this case, the court upheld several abortion restrictions, but it struck down some other abortion restrictions. Scalia was unhappy with the decision because he wished the court had upheld all of the restrictions, and he felt the decision written by Sandra Day O'Connor was a bit too wishy-washy, and so he insulted her directly. The outcome of today's case will doubtless be heralded as a triumph of judicial statesmanship. It is not that, unless it is statesmanlike needlessly to prolong this court's self-awarded sovereignty over a field where it has little proper business. Justice O'Connor's assertion that a fundamental rule of judicial restraint requires us to avoid reconsidering Roe cannot be taken seriously. We can now look forward to at least another term with carts full of mail from the public and streets full of demonstrators urging us, their unelected and life-tenured judges who have been awarded these extraordinary undemocratic characteristics precisely in order that we might follow the law despite the popular will, to follow the popular will. Indeed, I expect we can look forward to even more of that than before, given our indecisive decision today. Well, that was bad, but he was even more harsh in his dissent in Obergefell v. Hodges, which was the case that legalized gay marriage. Scalia, of course, was against gay marriage, and in his opinion he wrote, "But the court ends this debate in an opinion lacking even a thin veneer of law. The opinion is couched in a style that is pretentious as its content is egotistic. It is one thing for separate concurring or dissenting opinions to contain extravagances, even silly extravagances of thought and expression. It is something else for the official opinion of the court to do so. Of course, the opinion's showy profundities are often profoundly incoherent." Imagine if you were a student and these were the comments that a professor left on your paper. Probably wouldn't be getting a very good grade. Another classic example was in Ward's Cove Packing Company v. Webster, in which the Supreme Court struck down an affirmative action program. Harry Blackman, in dissent, wrote, "One wonders whether the majority still believes that race discrimination, or more accurately, race discrimination against non-whites, is a problem in our society, or even remembers that it ever was." So Blackman is essentially saying that the majority in this case cares a lot about discrimination against whites, but doesn't care at all about discrimination against non-whites, essentially calling them racists. That's pretty harsh. Because they are human beings, sometimes their opinions take on a very personal tone. Of course, they shouldn't be personal, as we've talked about. The whole purpose of putting on the robes and the legitimacy of the court is to present the impression that the court is comprised of neutral scholars of the law and that their own personal opinions and their own personalities don't matter. But sometimes they simply cannot help themselves, and sometimes these opinions can become extremely poignant as a result. One of the classic examples occurred in Planned Parenthood v. Casey in 1992. In this case, the court upheld various restrictions on abortion, so this was starting to overturn Roe v. Wade. And it didn't overturn Roe v. Wade fully, but it did move in that direction. And it claimed to be upholding abortion rights, but in fact it was going in the opposite direction. Harry Blackman was on the court at this time in 1992, but he'd been on the court for a long time. He had authored the Roe opinion back in 1973, but he was getting old and he was about to leave the Supreme Court, and he knew it. And so he wanted to make this a election issue. He wanted the American public to think about how close the court was to overturning Roe v. Wade, and he wanted them to vote in favor of a presidential candidate who would appoint justices who would uphold Roe v. Wade. It's an explicitly political thing that he wanted, and he communicated it in his partial concurrence in an extraordinarily personal opinion. He wrote, "I am 83 years old. I cannot remain on this court forever, and when I do step down, the confirmation process for my successor may well focus on the issue before us today. That, I regret, may be exactly where the choice between the two worlds will be made." This was a political plea to voters. Please vote for a Democrat so my successor will be pro-choice rather than pro-life. And notice we talked earlier about the fact that justices like to retire when there's a president who will appoint a successor that's similar to them, and Harry Blackmun is saying exactly that that's what he was planning to do. But probably the very most personal example ever to appear in all of Supreme Court history occurred in a case that I talked about earlier in the semester, and this is Callins v. Callins in 1994. Callins v. Callins is not a significant case except for the opinions that were written. In this particular case, a death row inmate had appealed their death penalty to the Supreme Court. And if you recall, Harry Blackmun was a Nixon appointee who over time had become liberal on most issues, but for most of his career he still supported the death penalty. So he was liberal on most things, but he was conservative when it came to the death penalty. But finally he changed his mind in 1994 when he was just about to leave the court. In fact, this was the very last death penalty appeal that Harry Blackmun ever dealt with when he was on the Supreme Court. So he just waited until the very end, but he changed his mind. Finally, at the end, he decided that he didn't think the death penalty was constitutional anymore. And so, when the court turned down this death penalty appeal, Blackmun wrote a dissent saying that the court should have accepted the case for review and that they should have declared the death penalty unconstitutional. And in writing this opinion, it was one of the most personal opinions we've ever seen. And Scalia wrote a response. So let's take a look at both of them. First, we'll take a look at Blackmun's opinion. On February 23, 1994, at approximately 1 a.m., Bruce Edwin Callins will be executed by the state of Texas. Intravenous tubes attached to his arm will carry the instrument of death, a toxic fluid designed specifically for the purpose of killing human beings. The witnesses standing a few feet away will behold Callins, no longer a defendant, an appellate, or a petitioner, but a man, strapped to a gurney and seconds away from extinction. 20 years have passed since this court declared that the death penalty must be imposed fairly and with reasonable consistency or not at all. And despite the efforts of the states and courts to devise legal formulas and procedural rules to meet this daunting challenge, the death penalty remains fraught with arbitrariness, discrimination, caprice, and mistake. From this day forward, I shall no longer tinker with the machinery of death. For more than 20 years, I've endeavored, indeed, I've struggled along with the majority of this court to develop procedural and substantive rules that would lend more than the mere appearance of fairness to the death penalty endeavor. Rather than continue to coddle the court's delusion that the desired level of fairness has been achieved and the need for regulation eviscerated, I feel morally and intellectually obligated to simply concede that the death penalty experiment has failed. Extraordinarily poignant, portraying the death of a death row inmate in very graphic terms. Well, Antonin Scalia didn't like this. He felt it was too maudlin, too emotional, and of course he supported the death penalty, and so he wrote a rejoinder, which was, again, extremely personal in the way that it attacked this statement by Harry Blackmun. In fact, it's kind of mocking. Justice Blackmun begins his statement by describing with poignancy the death of a convicted murderer by lethal injection. He chooses, as the case in which to make that statement, one of the less brutal of the murders that regularly come before us. The murder of a man ripped by a bullet suddenly and unexpectedly, with no opportunity to prepare himself and his affairs, and left to bleed to death on the floor of a tavern. The death by injection, which Justice Blackmun describes, looks pretty desirable next to that. It looks even better next to some of the other cases currently before us, which Justice Blackmun did not select as the vehicle for his announcement that the death penalty is always unconstitutional. For example, the case of the 11-year-old girl raped by 4 men and then killed by stuffing her panties down her throat. How enviable a quiet death by lethal injection compared with that. So you've got Harry Blackmun bearing his soul, saying that he's changed his mind after a lifetime to now oppose the death penalty, and Antonin Scalia simply mocking him and saying we ought to care more about the victims than the perpetrators.